to the Putting Your Business on the Map podcast. This is the podcast for land surveyors that own or want to own a small business. My name is Landon Blake. I am your podcast host. Let's dive right into today's episode.
The title of this episode is An Introduction to Contracts for Professional Services. Contracts are a really important part of managing a small land surveying business. One of the most important parts. Primarily because they can help you manage your liability and they can also help you keep good relationships with your clients. The other reason contracts are really important is because we don't do a good job teaching people about them. When I say we, I mean as a profession, we don't teach a lot about contracts. Most of what I have learned about contracts, I have learned by being a member of the American Council of Engineering Companies, which is a professional association for civil engineers and land surveyors in private practice. There's a affiliate association in each state. So we have ACEC California, which I'm a member of. I strongly encourage you, if you're a land surveyor and private practice, to consider participation in that organization. You have to do that at a business level, but I encourage you to do it. I encourage you to think about it if you're a business owner. It's taught me a great deal about business, and I'm very grateful to the organization for that. It has been the main venue that I have used to professionalize as a land surveyor. To professionalize as a business. Surveyors aren't very good about business management or just being professional. We tend to be kind of crusty, dirty hermits. And so ACC has helped me be more professional. It's a really beautiful thing that organization has done for me. They're not perfect. I don't love everything they do, but I agree with most of what they do, and they've certainly benefited me. So there's my plug for ACEC. That is not a paid promotion. That is a genuine recommendation. I also learned about contracts from my friend Dave Woolley. He's a friend and a mentor of mine, and he's taught me about contracts primarily because he does expert witness work and he actually reads contracts, which is unusual. So he's taught me quite a bit. And then I've learned some things on my own. So I want to share some of that knowledge in the episode today. Regretfully, it has taken me too long to do this. We should have talked about contracts way early on, and here I am down in episode 35. I don't know how that happened. This should have been like episode 4, probably, or 3. But here we are. We'll talk about contracts today. It sounds boring, and it can be boring, but it's really important. So in an effort to avoid a little bit of the boredom, I'm going to tell you a couple stories. So these are things that have happened to me in the last 5 years. And since I started the business, since I started Redefine Horizons, and they both had to do with contracts. So I had an opportunity to work for a large contractor. When I say large, I mean large. Like they build stuff across the United States. And I had a contact there. I had a contact who was a civil engineer that went to work for the company. And he's a good guy. And so he brought us on to do some work for his contractor. And we had to sign their contract, which I didn't love. But that's just the way it works when you're dealing with a big organization like that. You either sign their contract or you don't take the work. And I think they were willing to make a couple minor modifications to the contract. A lot of times big organizations aren't. But one of the things that they did, that they have in their contract that I did not love and they were unwilling to take out, was they have a clause in there that essentially says you have to keep working even if they refuse to pay a bill, refuse to pay an invoice. You have to keep working while that dispute is settled. And I understand why they have it in their contract. The contract was primarily made for subcontractors, not professional consultants. And they don't want a sub holding up a project and essentially holding the prime contractor ransom. So I went ahead and signed the contract, even though it had that language in it. I'd never signed a contract like that before with that kind of language, and I will never sign another contract again like that. So basically what happened is those guys were, I don't know, 4 or 5 months late paying a $70,000 bill or $75,000 bill, which at the time, I mean, it'd still be a huge deal for us, but it was pushing us to the edge of insolvency. And so I called the engineer that I was working with. Actually, he called me and he said, hey, I need XYZ on this project and I need it next week. And I told him, I said, well, that's a problem. I said, I'm not going to make your project a priority because you guys are 5 months late paying my bill. And I can't remember exactly what he said to me, but he said something like, well, I don't see how those two issues are related. And well, for me, they were very related. Now, in this guy's defense, like I said, he's a good guy. In his mind, he worked for a giant company, and in his mind, it's like, well, I'm not in charge of what the building department does. Like, I'm trying to run this design. Get me what I need. But I told him, I said, hey, they are related. Like, I don't keep working for people that don't pay my bills on time. And he basically said, well, our contract says you have to keep working whether I paid your bill or not. And I went back and read the contract and yep, that's what it said. So I got back to him and I said, all right, I'm going to go ahead and keep working. And the compromise I reached with him and said, I'm going to deliver your XYZ, but I'm not going to sign and seal them. And I'm going to make it clear that they're preliminary. And you rely on them at your own risk and I said, then when you pay my bill, I'll send signed final copies. But that put my company in a tough spot because now they owed me a lot of money and we were close to, being insolvent. And now I'm having to do additional work without having my bill paid. I will never do that again. I will never sign a contract with that kind of clause again. It's essentially a clause that says you can't stop work if your bill's not paid. And I won't do that. Right now, our agreement that most of our clients sign, which is a fair agreement, says if the client stops paying my bills, I have the right to stop work. To be clear here, I'm not talking about termination of the contract. That's not what I was asking for. I just was telling this guy I'm not doing any more work till I get my bill paid. And he forced me to go back to work, and he could do that because it was in the contract. I'll tell you another story. I'm doing some work for a civil engineering company. We had a master services agreement with them. And one of the things I didn't like about their master services agreement was it said that I had to hand over CAD files whenever they demanded that. And if you've been surveying for a while, there's some good reasons why you might not want to hand over your CAD file. We'll have to do another episode on that, or maybe a PYBO team extra. But anyways, this engineer had a bad habit of telling me, hey, I need you to give me a coupon deal on phase 1 of this project, and then when we do phase 2, you'll be able to make up the difference. I don't know if he was outright lying to me. I think that's possible. I don't think he was trying to cheat me. I think he had good intentions, but inevitably what would happen is we would get into phase 2, or phase 2, I'd give him the coupon deal in phase 1. And what would happen to me is he'd come to me at the end of the phase 1 and he'd demand my CAD files. And then he would handle the phase 2 work internally and basically cut me out of the deal. And obviously I only did that 2 or 3 times and then I ended the relationship. But, there was a situation where that contract term to deliver CAD files, seriously hurt me, right? Because we would do, so in one of the scenarios we had done an Alta survey, and then the client had made some changes and wanted an update, and I was supposed to get the work to do the update. We had an opportunity to make up a little bit of the money there after we gave him the coupon deal on the first Alta. And instead, he demanded my CAD files. They made the edits to the Alta, and I didn't get paid. I didn't get paid to do the Alta update. So those are just, that's 2 examples in the last 5 years of how contract language can really make a difference. Let me give you an overview of what we're going to talk about in this episode. Number 1, we're going to give you a definition of a contract. So what is a contract in the business setting, small business setting? 2, what are the parts of a good contract? 3, what supporting documents need to go with your contract? 4, we're going to talk about why you actually need a contract. 5, we're going to talk about critical elements that you need to carefully consider if you're going to sign a client's contract. I've got, a half a dozen of them. And we're going to talk about following the golden rule and how the golden rule applies to contract negotiation and contract language. And then finally, we'll talk about what do you do when there's a disagreement about contract language, because that happens sometimes. Okay, let's dive right in. What is a contract? A contract is a written business agreement. So it's a legally binding agreement in writing between parties, between usually 2 parties. Could be more than 2, but it's usually 2 parties for commercial purposes or for business purposes. It clearly defines the specific terms, obligations, and expectations that the parties are going to agree on. And it creates a record in writing, right? Which you could take that written agreement to court and enforce it if there's a dispute. And it also helps prevent misunderstandings, and we'll talk about that a little bit later. Okay, so it's a written agreement between usually 2 parties. It just basically says what they're going to do and how that's going to work. Basically how the relationship is going to work. Okay, so what are the good parts of a contract? I think I've got 10. Okay. Now you might say 10? That's a lot. Yeah, it is a lot. Contracts are complicated for a reason. You think about it, it's almost like getting married. Maybe not quite like getting married. Getting married is like a master services agreement. A contract is like you're gonna date a young lady or a young man for I guess it might be an old lady or an old man. You're gonna date a significant other for 6 months or a year or 18 months. Maybe you guys are gonna share a place. You're gonna move in. Yeah, there's a few things to talk about before you move your boyfriend or girlfriend in to your apartment, right, or your house. So yeah, it's complicated because you're essentially defining a relationship. So here's the 10 parts of a good contract. Good contract clearly explains what you're going to do for the client. What are you going to do? Why are they hiring you? That's what we call scope of services. So that's number 1. Number 2, a good contract clearly explains what the client is obligated to do for you in return. Now that usually is giving you some kind of payment, but it could also include, providing site access or providing documents that they have in their possession, that kind of thing. A good contract clearly identifies the parties, name and legal address. A good contract clearly specifies the payment terms. That's not just how much you're getting paid, but when you're getting paid and acceptable methods of payment. You don't want somebody showing up in your driveway with a dump truck full of pennies. That would be difficult. A good contract also going to have a schedule. So define the timeline for the work, including start dates, key milestones if you need them, completion dates, and how long the agreement's going to last. Sometimes you'll have an agreement. You'll have an agreement that the client wants to have in force for some period of time after the actual project ends. I don't like that. I don't like signing those kinds of agreements. I will occasionally, but I usually ask for a pretty short period. But yeah, I've had clients say, yeah, we want the terms of this agreement to be enforced for 5 years after the job ends. Like, yeah, I don't do that. But so that's something that needs to get addressed by the contract. Let's see where we at. I think this is number 6. A good contract clearly outlines the specific conditions under which the contract can be terminated by either party before the terms are complete. So usually for me that means non-payment by the client. And to be fair, I think our standard agreement has a clause that allows the client to terminate if we're not performing after some written notice. Number 7, a good contract clearly defines how disagreements or disputes are going to be resolved. Do you have to go to mediation or arbitration? What jurisdiction is our disputes going to be handled in? Who pays? How do you pay for that dispute resolution? A good contract clearly talks about any understandings or conditions about the client deliverables. a good contract, I think that was 8. A good contract clearly defines how confident, what kind of information might be confidential, how confidential information is shared, who's responsible for, making sure that confidential information doesn't become public or go to people that it shouldn't go to. That's not a huge deal for us most of the time. But every once in a while, we get asked by a client to sign an NDA if they're doing land development. Sometimes in land development, you don't want, Amazon doesn't want people to know they're in the neighborhood shopping for a warehouse, because then the price of all the real estate goes up. So sometimes we do occasionally. We don't do it a lot, and I don't like doing it, but occasionally we will sign an NDA in that situation. And then I think for land surveyors, a good contract is going to talk about things like the standard of care and copyright and ownership of data. We're going to talk about that. I have some special considerations here at the end. Okay, so that was a pretty comprehensive list. Right? So you want to make sure that your contract covers all those things. And I highly encourage you, if you haven't started a business yet, but you're about to, or you recently have, use the standard agreement from your professional association as a good starting point, because they had lawyers work on those. Or hire an attorney to help you come up with your contract. I'm not going to get into it in this podcast, in this episode, but I want to do another episode about plain language. So we use plain language agreements. And I think plain language is really important in business. I'm a big advocate of plain language. And the only reason I'm bringing that up now is because lawyers are not necessarily advocates of plain language. So just be careful if you hire an attorney that they don't write you a contract that you can't understand. So plain language is important. All right, before I jump to the next section here, which is the supporting documents that you want to include with your contract, let me just tell you a little bit about how you could get started with GIS if you're a land surveying or engineering organization. Maybe you're a small utility, or you work in the real estate or engineering department for a hospital or a university. You don't need to buy ArcGIS Pro and spend $5 million. It's way easier to get started with GIS. You can do that with QGIS. It's an open source desktop GIS. If you are a fan of the podcast, you've heard me talk about it before. Check it out. QGIS, just search for that on the web. You can download it right now today. If you tinker around with QGIS and you think it might be a way for your organization to get started with GIS, reach out to us. Reach out to me at Redefine Horizons or my team, and we can help you. You can take some of that money that you're going to save on all that ESRI licensing, and you can spend some of that on consulting services. We can help you design your GIS and get it implemented. Maybe help you come up with your plan to transfer your CAD data into the GIS system. So reach out to us. My team does an excellent job of that. We'd like to hear from you. I appreciate Redefine Horizons being our sponsor for this episode also. Okay, so what documents need to be included in your contract? What are the supporting documents? You're going to have your scope of services. That's probably the most important project document. And in your scope of services, you want to make sure you have a project understanding, the description of the tasks you're going to perform, a schedule, a fee estimate or the fees, and understandings and exclusions. I'm not going to do it right now, but I will do a PUIBO Team Extra, and I'll show you one of our scope of services and just show you the different parts so you guys can see that. I think that'd be great. I'll try and remember to do that this weekend if I have time. We always put a cover letter in our proposals that go to the client. The reason I do a cover letter, and you've heard me say this before, is a lot of clients do not read your scope because it's technical, but they will read your cover letter. So we always summarize our scope in our cover letter. And I think that's important. I think send in the cover letter with your scope. If there's ever a contract dispute, that can help clarify your understandings and the intent of your intent and the other party's intent. So I think it is important to do cover letter. And then we have what we call supplements. So supplements are little pamphlets or memos that we tuck in with the scope. They're usually 1 page or 2 pages at the most. and they're just plain language, easy to understand information for our client about some of the technical things that might be in our scope. So we have one, that talks about what is a record survey and why do you have to pay for one? What are the limitations of utility mapping if we're doing utility mapping for you? What are some considerations for if you're going to do land development in California? What are some things you need to know about? So all of those are important supporting documents that go with your agreement. That's not your contract itself. Now, those from a legal perspective, they get incorporated into your contract, just like a legal description that refers to a subdivision map incorporates the map. But they're not the actual contract, but they're supporting documents for your contract. All right, let me take a quick break. When I come back, we're going to talk about why do you need a contract? Why is it important? Okay, why do you need a contract? Most people think you need a contract in case you get sued. And that's a good reason. But it's not the main reason. So, I've been in business for, I've been surveying for 25 years. And I've been in business for 5 years myself. I've only actually worked at a company that's been sued over a survey one time. And that's out of hundreds of jobs with hundreds of contracts. So, the main reason to have a contract is not if you get sued. And the reason I mention that is a lot of people try and have these, 200-page ironclad bulletproof contracts that they can take into court. And that's something, they do because they're afraid or because their corporate lawyers telling them that's what they need to do. But it's a really horrible way to do business, and it imposes a cost. It makes you difficult to work with. We turn down projects on a regular basis because of contract language. Yeah, when I say regular basis, I mean a few times a year we will turn down work because of contract terms. And it's kind of silly because 99% of those contracts never go to court. It's 1% or less. I don't know. We can ask Google real quick. I got it pulled up. Let's just ask. So let me just see if we can get an answer here. It'll probably give me an estimate. So, look, you always work with a contract, always. But it's not because you think you're going to end up in court. There's other practical reasons why you use a contract, and it has nothing to do with winning in court. Okay, so let's see. So it won't give me a percentage, but they do say 90 to 95% of cases, disputes are resolved before they even go to trial. So, I don't know what our 2% or 3% of your contracts are going to have some kind of serious dispute. And of that 2 or 3%, 90% of those are going to settle before trial. So, the chances of you going to trial on a contract are less than 1%. Okay, but I'm going to give you the legal reasons because, 1 out of 500 will end up at a trial. So, and it's important when you're in a trial to have a good contract. So let me just talk about the legal reasons to have a contract. It creates enforceability. So it makes your agreement legally binding, which means you can go to the court system and force some kind of a remedy or dispute resolution. It gives proof of what the agreed terms were. If you go to court, you can say, hey, here's what we agreed to. It's right here in the contract. It establishes the type of dispute resolution that you need to go through, and it can spell out the type of remedies that are available. So if there's a dispute, how do you solve it, and what kind of damages can be awarded. It makes sure that you comply with the law. So as licensed professionals here in California, we are required to have a contract by law. So you want to be able to meet that legal requirement. And it defines things like the legal jurisdiction and the process that you have to go through to get your dispute resolved. So we don't want to be going to Nebraska for a trial, right? So our contract requires that disputes be adjudicated here in California. Okay, so those are all the legal reasons. Like I said, that's a fraction of 1% of your contracts, probably, especially if you're smart. Now, surveyors do dumb stuff. What I would tell you is, instead of spending a bunch of time on a 400-page bulletproof contract, like, work on not doing stupid stuff that gets you sued. That effort is going to have a way higher return on value. So here's the practical reasons to have a contract. And you absolutely should have a contract on every job, no exceptions. But it's because of these practical reasons, I think. That's my opinion. Okay, so here's the practical reasons. There's 5. It sets clear expectations. And it defines exactly who does what, when, and for how much, and it reduces confusion. You know, most contract disputes and client relationships that go sideways are because of misunderstandings. It's not because the guy on the other side is just a criminal. That's not very often. Sometimes the guy on the other side is a criminal. I've been in a contract, at least twice I've been in contract with criminals. But all the rest of my clients have been good people. You know, they're good people. A contract helps you just prevent misunderstandings. That's why it's important. It sets clear expectations. It prevents misunderstandings, right? Sometimes you don't remember. People hear different things. That's why it's so important. So it sets clear expectations, number 1. 2, prevents misunderstandings. 3, it gives you kind of a roadmap for your relationship, right? Here's what we're going to do. You know, here's a timeline. Here's what our relationship is going to look like. You know, I think back to when my wife and I were dating. You know, and very early on in our dating, we defined the roadmap for our relationship. Like, she told me, like, hey, you know, I don't want to have kids. Like, you can't make your friends a priority over me. You got to love my family. Like, before we jump into bed together, like, you're going to put a ring on my finger. Like, one of the things I loved about my wife is that she wasn't messing around. Like, on our very first date, she started to set out, like, the roadmap of she basically was like, if you're interested in me, buddy, here's how this is going to work. And, like, now, a lot of people would say, oh, well, that would be such a huge turnoff for me. I was relieved and refreshed because I had been dealing with women my age, girls my age, that were more interested in just spending my money and getting my attention than they were in an adult relationship. And so I met my wife is 8 or 9 years older than me. I was super relieved to meet a woman with the maturity to, like, let me know what her expectations were. And one of the things that did was indicate to me that she wasn't playing around, right? It's a funny story I don't think I've ever told on the podcast. So that's what a contract can do, right? It tells your client, hey, we're serious here about having a business relationship. And here's what this relationship is going to look like, and here's our end of the deal, and we're gonna commit to you that we're gonna keep our end of the deal. A 4th practical reason is it helps to manage the scope. You know, clients tend to push scope creep, so the contract helps control that. You know, that's probably the number 1 reason we're taking a client back to our scope of services, our written scope of services. I wouldn't call it a dispute. It's just a tool. It's a tool to manage expectations. The client says, you know, hey, I've got an example of this right now. I'm working on a land subdivision map for a client in Central California, and there's an issue with secondary access, and he doesn't have the easement rights he needs. And so he's coming back to me and saying, like, hey, I need your help with the title company. We gotta go figure out if there's an easement. If there's not, I need you to write me a new easement. Like, I'm gonna take him back to the scope and say, hey, happy to help you with this, but it's not in the current scope, which means I need a scope modification to the scope. I need an additional service request, and you're going to have to pay for this, right? And we're not going to go to court over that, right? That's just me bringing him back to the scope. This is what we agreed I was going to do. This is outside of that agreement. I'm willing to help you, but then we have to modify our agreement. So it helps to manage scope creep. And as I mentioned, you know, it helps indicate to your client that you're a professional, right? Professionals have written contracts. Period, full stop. So those are all the practical reasons. Do not ever work without a contract. I got a friend of mine. I love him. I've been buddies with him for 20 years. He regularly works without a contract, which is illegal in California, and it's dumb, and I want to smack him around. He's getting better. He has contracts more often now, but man, that guy regularly works without a contract, which is horrible. Okay, the next thing I want to talk about is if you're going to sign a client's contract, what are some critical elements of their contract that you need to look at? And I'm going to give you the 4 most important. And I will let you know right here that most of the time your professional liability insurance carrier will review contracts for free and highlight red flags because they share that contract liability with you. So if you're not sure, you can send that client over to your insurance broker. Your professional liability insurance company will more than likely review that contract at no charge. Okay, but here's the 4 things that you got to look out for in a client's contract. What they call indemnification or duty to defend. What does that mean? That means if there's a dispute, you're going to pay your client's legal bills. Very dangerous, very expensive. And most of the time, not most of the time, but sometimes the client will ask you to pay their legal bills even if the lawsuit is not your fault. It's a really dumb thing for people to put in contracts because most of the time it's uninsurable, which means I can't pay that bill anyways. Do not sign a contract with that kind of language. Now, here's what I think is reasonable, and this is probably what your professional liability insurance carrier would tell you. You can sign a contract that imposes a duty to defend for your negligence. In other words, if you're negligent and your client gets sued because of that, you will defend them. You will pay their legal bills. That's reasonable. But I always tell people that should be reciprocal. The client should also indemnify you in case you get sued for their negligence. Because here's what lawyers do when there's a problem on the project. They sue everybody that touches the project. That's just how it works. That's good legal strategy. So you should indemnify the client for your acts of negligence. They should indemnify you for their acts of negligence. I will not sign a contract under any circumstances that requires me to indemnify my client if that indemnification is not reciprocal. And I do not, under any circumstances, ever sign a contract that requires me to defend my client. It imposes a duty to defend that is not tied directly to my negligence. I will not do it. It is not insurable. I do not want to lose my house in a lawsuit. I don't care how much money it is. I do not sign those kinds of contracts. So duty to defend or indemnification. Transfer and termination. You want to know if your client can transfer your agreement, who that might get transferred to, and you also want to know under what circumstances you can legally terminate the agreement. For example, if your client stops paying your bills. Look at that. That's number 2. Number 3, you want to be able to impose some kind of limitation of liability. So typically, I try and limit that to the cost of my fees, or at least the cost of my professional liability insurance policy. Here's the thing, man. If your client's asking you to sign a contract with no limitation of liability, you gotta talk to them. That's ridiculous. Come on. You're the land surveyor. Let's say you're the land surveyor on a freeway project. Reasonably, what should your liability be? Right? And look, if they want $10 million, if they want your limitation of liability to be $10 million, you tell them no problem. I'm going to charge you for the insurance coverage. I'm going to charge you for what it takes to get $10 million of insurance coverage. And I've had that conversation. We carry a $2 million insurance policy, but I had a client that wanted a $5 million policy. So I said, no problem. I will get a $5 million limitation of liability. But I said, I'm going to go to my insurance broker. I'm going to find out what that premium is, and you're going to pay it. And they did. They were willing to pay it. I got the extra coverage. We increased the limitation of liability. So look at that. And then the last thing is you need to define a process for how does the client ask for additional services, additional work. Make sure that's defined in the contract and there's a mechanism there. So those are the 4 things. Indemnification, duty to defend, transfer and termination, limitation of liability, additional service requests. All right. Going to talk about the golden rule for a minute.
So the golden rule is treat others the way you want to be treated. It's a good principle to follow in contracts for land surveyors. So what I'm going to tell you is don't ask others to sign a contract that you wouldn't sign yourself. We have a very fair agreement that we use with our clients. Most of our clients sign our agreement. I would say 90%. It's a very fair agreement. Now there was an instance where my partner Brian came to me and he said, I can't remember what the exact issue was, but he said, hey, we're asking our client to do something in our agreement that we're not willing to do. He said, that's not fair. We need to change that. He says, either it needs to be reciprocal or it needs to be removed. And I was like, you know what? You're right. That's one-sided. We need to fix it. And I think we made the contract term reciprocal. I apologize. I don't remember what the specific contract term was. We did that without being asked because we want a contract that's fair and not one-sided, right? So, you'll talk to people in the business and they'll be like, oh yeah, do everything you can to make your contract, to structure a contract that's to your advantage. That's not how we want to do business at Redefine Horizons, and I don't think it's how you want to do business. I think we try and put ourselves in the client's shoes. Like, what does the client want? You should have a fair and reasonable contract. The contract shouldn't be structured to your advantage, overtly, unreasonably to your advantage, and it shouldn't be structured unreasonably to the client's advantage. It should be fair. By the way, that is an issue that judges will consider in a contract dispute. If you go to court with a completely one-sided contract, the judge is going to be like, all right, this is not reasonable. Something fishy is going on here. In the common law, what they call the common law, they have this concept of equity. Okay? Equity means fairness. So it doesn't matter. I shouldn't say it doesn't matter. You can have situations where even if the letter of the contract says X, if X is unreasonably unfair, a judge may say, hey, even though the contract says X, that's not reasonable. Out of equity or out of fairness, I'm going to only enforce Y. So it doesn't look good when you go to court with a completely one-sided contract. Okay? It doesn't look good, and it's horrible for business. So have a fair contract. Don't ask others to sign a contract you wouldn't sign. Okay, the flip side of that is don't sign a contract that your client wouldn't sign. So this happens all the time when we are asked to work for big civil engineering companies. They send us some contract with some crazy poison pill language in it. Something like duty to defend. Like, we'll defend you in any lawsuit for any reason, whether it's our fault or not, from now until we die. Like, I just don't sign that kind of language. And I've been on the phone with civil engineers or with their attorneys and just said, would you guys sign a contract with this language? No. Well, then why are you asking me to sign it? Right? That's an example of a one-sided contract. Don't sign those. So don't sign a contract that your client wouldn't sign. And then sometimes in those situations, this is kind of a side note here. Sometimes in those situations, we'll have a client say, well, we don't have any choice. That's what's in our prime contract and it has to flow through to you. That's an excuse. I don't accept that. And you know what I tell the prime as well? That's unfortunate then that we can't do business together. Like, you should have been a little more careful about what was in your prime contract. Right? And by the way, most of the time, that's a lie. They don't have to flow those terms through. In other words, they could absorb the risk or liability, right? They're trying to pass their liability on to their liability that they incurred for their risk that they incurred for signing a bad prime contract, a bad contract with the client. Now they're trying to flow through to you as a sub-consultant. And I just don't put up with that crap. I just don't. We just don't sign contracts with clients that have bad poison pills terms, whether it's in their prime agreement or not. We will walk away from work, and you got to be willing to do that sometimes. Next, we're going to talk about what do you need to do when there is a disagreement about a contract. So disagreement about the contract language. Before I'll do that, I'll let you know, a lot of you guys that are listening to this podcast are using Google Earth to manage your survey data. That's okay. Google Earth is a cool tool. I dig it. We use it at RH. I want you to think about moving to a system where you use QGIS to do that. Open source desktop GIS, QGIS, much more powerful. And
It can work with Google Earth files. It can import and export KML or KMZ files. So if your field crews and other people in your organization are already used to working with Google Earth, you can continue to do that. You can continue to allow those other people in your organization to work with Google Earth files, but you can have the power of a real GIS on your desktop. If you want to know how to do that, reach out to the team at Redefine Horizons. We can help you. It's part of what we do. We offer GIS consulting services built around QGIS. Thank you, RH, for being our sponsor today. What do you do when there is a dispute, a disagreement about a contract? So I'm trying to think of an example. Here's an example from just a couple years ago. I signed a contract to do some work marking some forest boundaries, and the specification that we were working under said we only had to replace damaged signs, not install new signs. And we got on the ground, and we realized, and the client realized, that there weren't a lot of existing signs because these lines haven't been surveyed in 50 years or more. And so now the client comes to me and they says, well, if there's not a sign, you have to put in a new sign. And I said, hey, whoa, like that's a ton of extra work, and that was not in our contract. So that's an example of a dispute. So what do you do when there's a dispute? So I'll give you a list of things I think you should do. I'm going to give you a flow chart or a process to go through, and then I'll come back and tell you what happened in that example. Before I give you the process or the workflow, I'll tell you, look, usually a contract dispute is about the scope of services. It's not about the payment terms or the limitation of liability. It's usually about what's in the scope, 95% of the time, I would say. So that's why it's important to write a good scope of services. And we'll talk about that in a different episode. Okay, but usually the contract dispute is about the scope. Now, when I say dispute, I'm not talking about a lawsuit yet. This is just a dispute could become a lawsuit, but it's not a lawsuit yet. Just a dispute or a disagreement is you and the client have a disagreement. So if you go back to that example I gave you, they're telling me I got to put in a bunch of extra signs. I'm telling them that's not in my scope. We have a disagreement. So what do you do? Step 1, try and determine the root cause of the problem. Okay, in this case, the real cause of the problem was we had a contract specification that was not appropriate for the conditions on the ground, and nobody knew that till we got out there. They weren't intentionally trying to screw me. We weren't trying to weasel out of work that we were supposed to do. It was like an unfortunate unknown based on conditions on the ground that we could not foresee in advance. The world is complicated. That happens. So try and determine the root cause. Now, that was important in this example I'm giving you because what that told me is I'm not dealing with the client who's a criminal. We have an unforeseen circumstance, and we're going to have to figure out how to deal with it. Number 2, recognize your client's perspective or opinion. So in that story I'm telling you, we went to the client. We said, yeah, we can understand why you're asking us for this. Your client, the Forest Service, is going to expect to see those signs. Even though it's not in our scope, we got to figure this out. So we recognize their position. The third thing to do is ask the client, do you understand our perspective? And sometimes they'll say, no, we don't. But a lot of times just asking that question gets them to think about it. And we had a good client in this scenario. So we just went to our client and say, we understand that the Forest Service is going to demand that all these signs be put in. We say, do you understand that is not in our scope and that is going to impose a significant additional cost on us? And they said, yeah, we do. We understand that that's more than you guys probably signed up for and that it's going to cost some money. So that was good. We wanted to hear that. Okay. Number 4, ask your client what alternatives they would be willing to consider. Say, hey, maybe you can't give them what they want exactly, but maybe there's an alternative. Now, in this case, we didn't really have a good alternative. But what we told them is, hey, if you guys are willing to work with us a little bit on the payment terms, and if you're willing to pay us a little more regularly, then we might be willing to absorb the cost of some of this extra work to put these extra signs in. Number 5, remember your BATNA. That's your best alternative to a negotiated agreement. that keeps you reasonable. Don't go to court. You don't want to go to court. The only people that win when you go to court with a client over a contract dispute are the attorneys. Period. Full stop. Nobody else wins. Like, that's why attorneys drive BMWs, because people can't be reasonable. So remember, your alternative is an expensive trial, potentially, and that will keep you reasonable. You know, in almost every case, when there's a dispute over a contract, I can honestly say every time in the last 5 years we've had a disagreement with a client about a scope issue, and I don't know, it's happened a half a dozen times in 5 years. So once or twice a year it happens. In almost every circumstance, Brian and I and Danny, when Danny was a partner here, compromised with the client. Even if we didn't think we need to, even if we thought we were right, even if we thought they were being unreasonable, even if we thought we would win in a lawsuit, we compromise. Because we understand that lawyers are expensive. And oftentimes, reaching a negotiated settlement of the dispute, even without attorneys, just coming to a compromise with the client, saves everybody money. Right? And protects our reputation as being reasonable people. I mean, I'm talking about a lot of money. One time, I had a client. We did some work for him. We had an $18,000 invoice. It was in scope. They agreed to pay us. They had paid us some other money on that project, but this was like the last invoice. And they're like, we're not going to pay you that. And I didn't think that was fair, but here's what I told the client. I was like, you know what? I'm not going to take you to court for $18,000. Keep your money. We don't want it. We're not going to sue you. Keep your money. Like, we haven't done business for that client again, and we never will. Right? But we didn't sue him over the $18,000. Like, sometimes you lose $18,000 to not go to court. And the last thing is consider the long-term relationship. I am much more willing to compromise with a client that I have a long-term relationship with, because I'm considering that. Well, first of all, they're our friends usually, and I'm considering that the value that's going to be in that long-term relationship. You know, I'm less willing to compromise for a transactional client. You know, if we're doing an Alta survey for somebody that I'm never going to see again, I'm way less willing to compromise. Like, yeah, just pay my bill to get your product. Right? Because there's not a long-term relationship there. So think about that. You want to consider that. You know, you don't want to take a good long-term client to court. If you can, you want to avoid that. All right, I'm running out of time. So here's what I want to do. I want to talk a little bit. I'm going to do second episode. Sorry, I got something on my shirt that's bothering me. I'm going to do second episode on this. We're going to talk about special contract considerations for land surveyors. So I've got 7 things you want to think about that are kind of specific to land surveyors that you need to address in your contract. And then I want to talk a little bit about plain language and why I think plain language is important in contracts. And maybe we'll take some time and I'll jump on the computer and I can show you our plain language version of our agreement. And we can look a little bit about how you can craft plain language. Because I think it's really important. It's an important principle that we use here, an important value or operating principle that we use here at RH. You know, we like to communicate with our clients using plain language, not technical jargon. And I think that's one of the reasons why clients like to do business with us. So I'll do a second episode on contracts. We'll talk about special contract considerations for land surveyors. We'll talk about plain language. I'll show you our plain language agreement. Maybe we'll look at a couple of examples of where you can take language that's confusing and make it more plain. I think that would be great. So we'll do that. And then the next episode up in the hopper after that is how to use content marketing in your land surveying and mapping business. That'll be another episode in our series on finding good clients. I appreciate you guys taking the time to listen. I know everybody's busy. Don't forget, reach out to RH if you'd like to learn about how you can use QGIS at your surveying and mapping organization. And I'll catch you guys on the next episode, part 2 of contracts for land surveyors. As we close out the episode, we just want to give you guys a few reminders. First, we want to let you know where you can find the podcast episodes. The podcast home on the web is at my personal website, landonblake.com. If you head there and look under the Learn menu, you'll find a link for the podcast. That homepage for the podcast has all of the episodes. You can download those in MP3 format if you'd like, or read the show notes. You can also find the podcast on Spotify, YouTube, and Amazon Music.
So those are your preferred. One of those is your preferred distribution channel. You can find the podcast there. We also want to let you guys know, if you'd like to sponsor the podcast, you can reach out to me, sunburn.surveyor@gmail.com. You can also send me questions, comments, thank yous, topic suggestions for the podcast. I regularly get that kind of feedback from listeners, and I dig it. I appreciate hearing from you guys, so I encourage you to do that. We also have a Patreon page. If you cruise over to Patreon, you can search for On Point Workshops, and you will find the podcast there. You can, for a small monthly donation, I believe right now it's $10 a month, you can support the podcast and get access to what we call PYB OTM Extras. So those are extra videos, short audio files, and even full episodes of the podcast. And that support on Patreon allows me to keep Carly around. Carly is the fantastic young lady that helps me edit the podcast and maintain the podcast website. We'd like to keep her around, so we appreciate your support on Patreon if you're able to do that. And thank you for being a listener.